So when we talk about a custody battle where there's a lot of money, where both parties or one of the two parties is a high net worth individual, this can change the landscape significantly in many ways, both in terms of the amount of money that's invested in the case and in terms of the resources that are available to litigate the case, the options that one might choose. For example, it's very valuable in these cases where one of the two parties perhaps suffers some form of mental illness that might be damaging to the children to have a psychological evaluation. Now, this is something that often costs upwards of $50,000, which clearly for individuals that are financially strapped are not going to be able to afford. But of course, a psychological evaluation by a competent psychologist can shed a lot of light on the mental status, the mental health, the mental welfare of one of the parents, and can help the court determine whether or not this particular parent is the proper parent to have the majority of time or majority of parental responsibility. So that's one way in which there are more resources available during the litigation to an individual who has more assets at their disposal. Of course, the other way in which the finances affects the process is that there's a lot more to decide typically in these cases. We have issues of private schools. We have issues of distribution of assets for the children, both in the immediate and the long-term sense. We have issues of childcare for younger children and staff that might be involved in the care of the children. We have issues of curriculum and preparation for college and what sort of languages we want the children to learn, what sort of career path they might go on in the future, and what preparation we want to engage in order to prepare them for this potential career path. So all these issues create a much more substantial allocation judgment, whereas in regular cases, the allocation judgment, which is the divorce judgment that decides everything relating to the children, is the ultimate document that's going to come out of the case, is maybe 30 pages. In this sort of a case, it might be twice as long, for example, because there's a lot more that's involved, because there's a lot more available to decide how we're going to raise the children. So all these things, of course, require a competent and experienced and communicative family law attorney who understands these issues and understands how to leverage these concerns both in your and your children's best interest. So when we have a huge difference between incomes of the two parents, this is a factor that the courts will consider in determining the best interests of the children. Now, it's not a per se win to the more moneyed individual that this means that certainly they should gain custody because they have more financial resources. Because there will be a leveling of the playing field in terms of child support that's going to be paid to the other side, potentially maintenance or alimony paid to the other side, although there might be a premarital agreement that excludes alimony or property from the other side. So it is an important factor. If there is one household where certainly the children are going to be much more appointed and much more cared for, then that is a benefit that one side could receive, is a big chip that could exist on the table to favor one parent receiving majority parenting time. However, again, often child support can come into play, and even other expenses that the more moneyed party can be ordered to pay, medical, extracurricular, all of these things that can be, in addition to child support, ordered to be paid to help level the playing fields and give the other party substantial resources to help win custody. So needless to say, it's never a foregone conclusion that the more moneyed individual will win custody, but it certainly can be a huge factor in the process. So when we're talking about higher net worth individuals, it's not required that private education be decided by the courts, but often it is the preference. So there's no statutory obligation, but regularly, given the state of our public schools, judges do tend to favor this when the money is available to do so. So often it is the preference both of the attorney and the client that when that's an option, we fight for it in court. So in high net worth cases, we want to make sure that the money that's available for the children is leveraged in their best interest. In other words, that the panoply of factors that the statute determines are what the court should look to determine the best interest of the child should produce a monetary allocation that's commensurate with those statutory prerogatives. In other words, to put it more simply and with less jargon, we want to make sure that the money is available for education, for healthcare, for extracurricular activities, for psychotherapy if necessary, for all the things that might make for a healthy child, a healthy childhood, and be an investment towards a healthy adult life in the future as best as possible. So in this series, we've discussed divorce and child custody for high net worth individuals. We hope you've enjoyed the series. Please don't hesitate to reach out to your friends, your attorneys at khk.law for your free consultation.